Welcome back, Raven. The next mission requires some additional background regarding the Freedom of Information Act, or FOIA. On his first full day in office, January 21, 2009, President Barack Obama had issued a memorandum to all executive departments and agencies emphasizing that the FOIA reflects a profound national commitment to ensuring an open government. President Obama called for federal executive departments and agencies to administer the FOIA with the clear presumption, in the face of doubt, openness prevails. President Obama directed departments and agencies not to withhold information merely because public officials might be embarrassed by disclosure, because errors and failures might be revealed, or because of speculative or abstract fears. He instructed agencies to respond to requests promptly and in a spirit of cooperation. President Obama further directed agencies to adopt a presumption in favor of disclosure with regard to all FOIA decisions. That presumption requires agencies to proactively release records, without waiting for specific requests, and use technology to inform citizens about what is known and done by their government. President Obama directed the Attorney General Eric Holder to issue FOIA guidelines for the executive branch that reaffirm the commitment to accountability and transparency. That had been the state of the law, until recent events, related to DIA FOIA 00133-2023, concerning a job offer connected to federal job vacancy number CFO 103603-02 KDJ, a position as a procurement analyst that had been open for applicants to apply between November 7, 2014 to November 18, 2014. On June 28, 2022, a request for information, under the FOIA and Privacy Act, was submitted to the Defense Intelligence Agency, DIA. Petitioner had presented a simple FOIA request to respondent DIA, requesting 1. Any and all documents pertaining to the identity of the recipient of what was arguably an email exempted from disclosure under the exception for deliberative process documents, dated December 31, 2015, who had received information regarding a job offer to 2 applicants for a procurement analyst position at DIA, in a mission known to have expired. 2. Any and all documents pertaining to any follow-up correspondence from this approving official or senior level officer with regard to this transaction. 3. Any and all documents pertaining to the identity of the final approving authority for the job offer that was extended to requester. And 4. Any and all documents pertaining to any discussions or statements regarding requester's selection as a potential candidate for consideration for this position as a procurement analyst, as well as any and all documents pertaining to the decision to extend an offer, as well as a re-offer, when requester had permitted a short suspense deadline for reply to toll. Under the FOIA, an agency has 20 days to issue a response. However, since that time, over a year ago, DIA has yet to issue a response. Moreover, under the FOIA, on complaint, the District Court of the United States in the district in which the complainant resides, or has his principal place of business, or in which the agency records are situated, or in the District of Columbia, has jurisdiction to enjoin the agency from withholding agency records and to order the production of any agency records improperly withheld from the complainant, and any person making a request to any agency for records shall be deemed to have exhausted his administrative remedies with respect to such request if the agency fails to comply with the applicable time limit provisions. Similarly, under the Privacy Act, whenever any agency refuses to comply with an individual request, or fails to comply with any other provision of this section, or any rule promulgated thereunder, in such a way as to have an adverse effect on an individual, the individual may bring a civil action against the agency, and the District Courts of the United States shall have jurisdiction. In short, if a federal agency refuses to respond, a federal court has the power to compel the agency to release the requested documents to which a requester is entitled as a matter of right. And yet, in an initial action, filed against DIA in July 2022, the federal court dismissed the complaint on the argument that it was an inscrutable, prolix complaint, and the plaintiff refiled the action with the court on August 17 of this year. Under the Federal Rules of Civil Procedure, a defendant must serve an answer within 21 days after being served with the summons and complaint. Further, a summons, issued by the court, must be served with a copy of the complaint, and the plaintiff is responsible for having the summons and complaint served within the time allowed, and must furnish the necessary copies to the person who makes service. And, to serve a United States agency or corporation, or a United States officer or employee sued only in an official capacity, a party must serve the United States and also send a copy of the summons and of the complaint by registered or certified mail to the agency, corporation, officer, or employee, which was placed in the mail on August 18, and dispatched by priority mail to the Department of Defense. However, since that time, according to the U.S. Postal Service, they have no information regarding the status of this parcel. Perhaps the parcel had been simply lost in the mail. However, complicating matters is the fact that, prior to commencing the current action against DIA, on April 6, the requester had submitted another follow-up FOIA request to DIA, requesting all records connecting vacancy announcement CFO 103602-02 ADJ with DIA/UNC Chapel Hill Top Secret Special Access Program, which request was acknowledged and designated at DIA FOIA 00133-2023. The requester had alleged that it appeared plausible that the unsolicited job offer he had received in a top-secret billet, as a procurement analyst for an officially disavowed and expired mission, as one of only 3 persons determined to be fully qualified, had been connected to research on recombinant coronaviruses at that research university in North Carolina, and, intriguingly, DI had not denied the possibility that the job offer had, in fact, been connected to what could only have been defense-related, dual-use research of concern for this defense agency to have been involved. And, certainly, had this been the case, the Department of Defense would certainly derive a benefit if it was able to claim that it had never received the civil complaint and summons regarding its refusal to respond to the original FOIA request about the suspect job offer. That is your mission brief, Raven. How would you handle this situation, using your best discretion and judgment? Recall that it is a felony to attempt a conspiracy to evade the service of a summons, punishable by up to 20 years in federal prison. And, evidence of flight is admissible even if offered solely to prove his consciousness of guilt as to that predicate act. Did you wake the president? This concludes this simulation, and you shall be contacted with the results. Thanks for your participation. That is all. Carry on.
This message was approved by Major Mike Webb. Honest.